Estate planning mistake number 6. I have a living trust, so my IRAs and qualified retirement plans are fully protected. Well, unfortunately, many estate planners are not familiar with the intricate tax rules that apply to IRAs and qualified retirement plans. These have to be considered properly when doing your estate plan. Because of newer IRS rules, IRAs and qualified retirement plans that may be rolled over into IRAs both during your lifetime and after you pass away have much more potential value to your beneficiaries. In fact, with proper planning, your IRAs and qualified plans may essentially become the retirement plan for your loved one. Now, here's the key thing. Under the new IRS rules, now a beneficiary can stretch out the taxable required minimum distributions over their entire lifetime, not just your remaining lifetime. So instead of a beneficiary having to take out the money, pay taxes on it in as little as 5 or 10 years, now a beneficiary could allow the money to accumulate inside the IRAs or qualified plans rolled to IRAs now for their entire lifetime, and over that time take out the taxable distributions. Let me show you how powerful this income tax stretch out when done properly is. If I'm a 50-year-old beneficiary of yours and I inherit $200,000 in IRAs and qualified plans from you. Now, if you're husband and wife, we're combining them together. Okay? So I receive $200,000 in IRAs and qualified retirement plans. And let's assume an annual rate of growth from income and principal growth, inflation, good investing of 6% a year. If I take out only required minimum distributions for the next 30 years till I'm age 80, I will have taken out of that original $200,000 account almost $700,000 and still have almost another $300,000 in the account. You heard me right. With proper stretch out planning, your IRAs could be worth 4 times, 5 times, many more times their current value. And because of that increased future value to your beneficiaries, there's even more reason that those IRAs and qualified plans, when inherited, are also properly protected against the spouse in a divorce, against creditors or lawsuits, against a bankruptcy, against loss of government benefits, or even a second estate tax when the beneficiary dies and passes it to the next generation. Now, many planners think that you can just accomplish these things by having named individuals directly on your IRAs or qualified plans as beneficiaries, or name a living trust as beneficiary. Now, if you name individuals, you have no assurance or guarantee that they will stretch out those taxable distributions. In fact, most of the time they'll make the dumb mistake of taking it out too early, paying the tax, and losing all that future compounding tax-free. The other thing is, of course, when it goes direct to an individual, they have no asset protection against spouses, divorces, creditors, etc. Now, a living trust can protect against the spouses, the divorces, and other protective issues. But here's the key problem. With the typical living trust, you do not assure and guarantee the proper long-term stretch out of the taxable required minimum distributions. You can only achieve both the stretch out and the protection benefits of your IRAs and qualified plans through what we call the IRA Inheritance Trust. We're very proud to say that we were the very first law firm in the entire country to develop this IRA Inheritance Trust, to have it approved by the IRS in a public written ruling, and also have it trademarked at the Federal Patent Office. We license this trust and train other attorneys from all across the nation on how to use this powerful protective device. Experience and expertise do count when you're choosing your estate planner. If you have large IRAs or qualified retirement plans in excess in total of over $100,000 or so, you should be looking at this IRA Inheritance Trust.